Hello, welcome to this special focused discussion on foreigners' tribunals in the state of Assam. I'm Rupali Samuel, a lawyer practicing in the Supreme Court of India, and I'm really happy to welcome Dr. Professor Mohsin Bhat with me today, who is the co-author of this report, and who will be taking us through some of its key findings. Professor Mohsin is a professor of law at Queen Mary University of London School of Law. And this particular report has come about from a collaboration between three academic groups. One is, of course, Queen Mary University of London School of Law. Then there is NLSIU, the National Law School of India University, and Parichai Legal Aid Clinic, a legal aid clinic that has been committed to citizenship cases across the country, but particularly in Assam. It's a pleasure to have you here, Mohsin, and to discuss this very important topic. I want to start by reminding everybody about what the Indian Supreme Court has said about citizenship. Recently, in the judgment on Section 6A of the Citizenship Act, the Supreme Court referenced an earlier 9-judge bench decision and reminded us that citizenship is the right to have rights, and it is the most significant way to become a member of a polity and to then access other rights. So we are dealing with a very critical right that has not received the kind of in-depth analysis and the kind of attentive development of jurisprudence as many other critical rights have. And that's where this report makes an important intervention by documenting how citizenship has been adjudicated in these quasi-judicial bodies called the Foreigners' Tribunals in Assam, and the very serious gaps that have emerged in the way this legal issue has been treated by these quasi-judicial bodies. So, Mohsin, perhaps we can start by you telling our viewers what are the foreigners' tribunals in Assam.
Right. Thank you so much, Rupali. As in, these foreigners' tribunals, legally speaking, have been set up under an executive order, the Foreigners' Tribunals Order 1964. And this has been set up under the Foreigners Act, which, as many of us would know, is a colonial act. In fact, the act gives so much power to the executive that soon after India's independence, when this issue sort of marginally came up in the Supreme Court in the Hans Muller case in 1955, Setalvad, our Attorney General, basically accepted that the Foreigners Act was basically unconstitutional after independence. And despite that, the Act continues to this very day. And the reason why there are these concerns with the Foreigners Act is because it gives this unbridled power to the executive whenever it decides to treat who it describes as foreigners. And there's no particular procedure which is given under the Foreigners Act. And in 1964, the executive had this order setting up these foreigners' tribunals. Now, the history of these tribunals has actually changed over a period of time. Specifically in the case of Assam today, foreigners' tribunals appear to have complete power over deciding who is a citizen and who is not. In fact, ordinary courts do not decide this matter. And there's a long history to it. I would summarize it. In 1983, there was the IMDT tribunals that were set up in order to decide the question of the citizenship status of people. And there were several protections which were provided under the tribunals in order to ensure that people would not be targeted merely on the ground that the police or the community or anybody else suspected them to be foreigners. But in 2005, the Supreme Court, in the Sarvananda Sonowal judgment, held that the IMDT tribunals were unconstitutional and took all the cases that were being entertained by those tribunals to the foreigners' tribunals. And since 2005, the foreigners' tribunals had dealt with these cases. And I would just remind us what the stakes of these institutions are. There have been more than 436,000 cases that have been referred to these foreigners' tribunals. And among them, 165,992, so more than 1.67 lakh people have been declared to be foreigners. And therefore, the scale and the consequence of these tribunals is extremely crucial and really high. I would also add the different ways in which cases end up going to these foreigners' tribunals. One way in which foreigners tribunals get these cases is by reference by border police officials. And the other way is what is often called de-voter cases. So in 1996 and 1997, the Election Commission marked doubtful on the names of several people on voter lists. And many of these cases have now gone to the foreigners tribunals. In fact, we think that more than 370,000 people have been marked as de-voters. And since these cases have come up to the foreigners tribunals, according to our data, more than 50,000 people among them have been declared to be foreigners.
You've raised some really important issues, especially how these cases reach the foreigners tribunals. Now, if 4,36,000, I think is the number you gave us, 4,36,000 people have been referred to these tribunals, but there seems to have been no robust process by which these 4,36,000 people have been selected. So both routes, the border police route, there isn't any complaints process, there isn't any verification. There's supposed to be an actual verification on the ground, but these verification reports are not produced, they're not given to individuals. So nobody knows on what basis the border police has picked them out. And similarly with the marking of de-voters, so that happened in 1997 in Assam first. Now, of course, everybody's talking about it because of Bihar. But in 1997, when they did it in Assam, a large number of people who are vulnerable and who also, by virtue of, natural factors, family-related factors, became marked as de-voters on the list. And I'll just explain. We've noticed a large number of women who, after marriage, moved to their marital home in a different village, were marked as de-voters because they were new entrants in the village. Though this is a perfectly natural, explainable phenomenon. And similarly, people who reside near the Brahmaputra river, which floods on an annual basis and whose floodplain is continuously changing, they do have to change their village every couple of years. But people who move from one place to the other were also immediately looked at with suspicion and marked as de-voters. And since 1997, anyone marked as a de-voter hasn't been able to exercise their franchise at all, even though their cases have been pending in these tribunals now for so many decades. So it's really a very serious, significant issue. And in 2000, a case was filed in the Guwahati High Court, at least challenging this de-voter marking, the case of H.R.A. Chaudhary versus State of Assam. But the Guwahati High Court upheld the right of the Election Commission to conduct this exercise, also directed that they should conduct the exercise in a timely manner and ensure that these doubtful voters were then sent to the tribunal and their citizenship verified in a timely manner. But it's now 2025 and we still have this remarkable pendency before the foreigners tribunals. So this is a very serious problem and it came to the attention of the Supreme Court last year. So maybe you can tell us about the case of Rahimali in the Supreme Court and the judgment that came last year pointing out to these problems.
Absolutely. But before I even come to the Rahimali case, I think the case of H.R.A. Chaudhary is of great significance because Senior Advocate H.R.A. Chaudhary from the Guwahati High Court filed this case against the Election Commission. And it'd be useful to remember that the Supreme Court in the Lal Hussain case had actually held that even though the Election Commission does have the authority to regularly, frequently verify voter lists and update them, but when the Election Commission is removing people from the electoral rolls, this process must be individualized and must be based on natural justice because people must have the opportunity to be heard and they must be asked to provide evidence why the Election Commission, for instance, thinks that they should not be recorded on the electoral rolls, especially if the Election Commission thinks that somebody is a foreigner. This process was completely not followed by the Election Commission. In fact, the Guwahati High Court did not demand that the Election Commission follow what the Supreme Court had in fact held only a decade or so ago. So this absolutely is of great significance, and this undermines the democratic principle completely. Now, coming to the Rahimali case, now the case which was decided very recently by a division bench of the Supreme Court actually comes from a longer history of worries that we have seen in Assam on the ground, whether practicing lawyers or otherwise. Our report, Unmaking Citizens, has conducted several case studies, which include several interviews with very experienced lawyers who have fought cases at the Foreigners Tribunal level and also at the Guwahati High Court when it comes to the Foreigners Tribunals. And even though we record them in complete anonymity, we have reproduced those conversations. And it's striking how many of them say that inquiry reports and investigations are just not done, or they are manufactured, or they are not provided. Now, it'll be good to remember that whenever a case of suspected foreigners is referred to the Foreigners Tribunal, under law, both by ruling even before Rahimali, by the Supreme Court and by the Guwahati High Court in the Muslim Mandal case, required that grounds must be available to a person. And now that is necessary because under the Foreigners Act, the burden of proof under Section 9 is on the suspected foreigner. In other words, a suspected foreigner has the burden to prove that the person is a citizen, but that is obviously only possible once they are aware of why the state thinks that they are foreigners. And also they should have access to what evidence or material that the state is relying upon. There's also a requirement that investigation should have happened, because without such investigation, there will be clear violations of all fundamental rights and basic processes, due processes in natural justice. So this was known, and this is the most obvious rule of law requirement in these proceedings. But what the report documents through extensive case studies and interviews is that, one, these inquiries seem to not be conducted at all. And when the lawyers in the Foreigners Tribunals ask that grounds and inquiries be made available to them so that they can build a credible case and they have an opportunity to fight based on fair trial principles, more often than not, the Foreigners Tribunals refuse to demand that these inquiry reports be available. Now, that has led is that investigations seem to not happen, or the Foreigners Tribunals don't require that these happen. I think equally worrying is that when these issues come up in front of the Guwahati High Court has not taken them as seriously. In fact, the report documents cases in which these arguments were raised. In fact, they were even recorded, but the Guwahati High Court has just sent these cases back to the Foreigners Tribunals. Now, why is that significant? Because if there is no inquiry that has happened, there is a fundamental jurisdictional error. No case should be filed against a person, no case should be referred to the Foreigners Tribunal unless the state has applied its mind and an inquiry or investigation has happened. Without grounds, there is no case. But even in cases where this argument is raised in the High Court does not squash the Foreigners Tribunal proceedings, but basically sends this case back to the Foreigners Tribunals, which is rather obvious, frustrates the whole purpose of this requirement. Now, what did the Rahimali case hold? Rahimali case basically shows that this has been such a systematic practice that this required the Supreme Court to intervene. The Supreme Court in many ways held what should have been obvious. Supreme Court said grounds should be made available to people, there should be no arbitrary targeting, the initial onus must be on the state to do the investigation and have reasons and materials to show that its suspicion is well-founded. Now, obviously, it's nobody's case that the state should have completely conducted the investigation. It's not an open and shut sort of case in terms of the evidence that the state must provide, but that does not mean that there is no burden on the state at all. And that's what the Supreme Court has held. But our feeling is, based on what we've studied in the report, that the institutional practices in the Foreigners Tribunals are so entrenched, and unfortunately, the Guwahati High Court's role has not been as constructive as it could be. And because of these reasons, I personally am skeptical that the Honorable Supreme Court's decision will be followed in its spirit.
The Supreme Court actually says we cannot have knock on the door, inquiries against people where literally there's a knock on the door and you have no reason or no basis to know why you are, suspected of being a foreigner, and then you're dragged through this process, which we have to remind everybody, it's the most poor and most marginalized of people living in remote areas who are being dragged through this process. They do not have access to lawyers, they do not have the money for legal fees, and no legal aid is provided in these foreigners' tribunals at all. Unlike in criminal cases where legal aid is mandatory, even though there are very significant consequences that come from being declared a foreigner, including detention, there's no legal aid. And even in Rahimali's case, when they finally said there was no basis to proceed against him, it then emerged after the verdict that Rahimali was no more. So that's the tragedy of how process is also the punishment, not just for the individual, but also for the family, because of the way the phrase illegal migrant is defined under the Citizenship Act. The minute an individual is declared an illegal migrant, their children immediately also automatically become illegal migrants. So it's not just an adjudication on one person, it's an adjudication on an entire family and that family's future. So now I want to sort of go on to the question of who mans these foreigners' tribunals. So we talked a little bit about how they are set up under the Foreigners Tribunal Order, but can you just tell us a little bit more about the structure of the tribunals? And your report raises very significant concerns about their independence. So could you explain those aspects?
Yes, Rupali, I think that's a very important point, but I just wanted to add a few data points to what you said about detention and the impact and the stakes of what we are talking about. So our report collects the latest data on detention. And in 2019, this is before COVID, there were more than 1,000 people who were in detention. And this includes families. In fact, the number of children who have been in detention, at least until 2021, exceed 100. And more than 30 people have died in detention. And there are so many stories which we have witnessed on the ground, where even getting a notice from the Foreigners Tribunal scares people so much, quite legitimately, that not only does that push people into depression, into complete financial rout, but the people who have given their lives have committed suicide because they were so scared that they will be taken to detention. So this is a true human concern here. And just the thought that there are children and families in detention because of these processes, not just the abstract notions potentially of citizenship, should be of great concern. Now, coming to the question of the structure of these tribunals, as we know, there is tremendous jurisprudence in India which requires that if there is a body that is deciding legal rights of people, especially when those bodies displace or substitute ordinary courts, they should look and behave like courts. This is a fundamental rule of law requirement. And in the case of Assam, foreigners' tribunals do substitute ordinary courts to decide citizenship status. In fact, at least since 2013, ordinary courts do not have jurisdiction to decide citizenship status. And the stakes of that are even higher because foreigners' tribunals, being outside the ordinary court system, do not have an ordinary appeal to the High Court. The only way to reach the High Court is by filing a writ, and Guwahati High Court has ruled that it may issue a writ of certiorari, which is a limited power, and we will, of course, discuss that in further detail. So that being the context, and that being how these foreigners' tribunals are, the kind of powers that they exercise, it is shocking how little independence and competence that they have. So let me start with competence here. Since 2019, foreigners' tribunals are not governed by people who are retired judicial officers. In fact, in 2011, only retired judicial officers could serve as members. But by the time we reached 2019, retired civil servants or people or advocates with 7 years of experience qualify to be members. The only other qualification that seems to have been given, and these are all under executive orders, there's no legislation which could secure in any meaningful sense the independence or competence of these bodies, and therefore it's subject to constant change. But the latest requirements are that these people must have some understanding and appreciation of history of migration in the state of Assam. But what objective criteria can anybody use for that is anybody's guess. and there is no requirement to have any expertise in citizenship law or Foreigners Act or other relevant areas of law. So that automatically raises serious concerns about their competence. Coming to independence, what our report tries to show is that there is enough evidence already available in public record, which shows that Foreigners Tribunal members are not only theoretically subject to political pressure, but may already be succumbing to it. So in 2017, one former member of the Foreigners Tribunal, whose employment was not extended, and just to sort of note that Foreigners Tribunal members are appointed in short-term contractual basis, 1 or 2 years, and this particular person, Ashim Kumar Barua, went to the High Court and basically argued that the reason his tenure was not extended was because he was not declaring enough number of foreigners. And the data which the state then gave to the High Court, in fact, we have reproduced in the report. And what we've shown is that his allegation appears to be true. When we looked at all the members whose tenure was considered by the state government, we can see very clearly that those people who declared more people as foreigners had more likelihood for their tenures to be extended. But those people who did lesser number of foreigners, but may have even delivered on the percentage disposal rate, have actually not been renewed. So there are these serious concerns about independence, and that is in a way bound to happen when independence is not secured by legislation and by other institutional mechanisms.
So, I mean, this is a really shocking revelation, which we have known for now a couple of years, that the performance of the individuals who are hired on contract is judged based on outcomes and not on overall disposal. Which really just goes to the heart of the independence of these tribunals.
Absolutely.
And their conditions of service is also not guaranteed or consistent because it's not under statute, it's not under rules, it's on the basis of ad hoc notifications that are issued.
Absolutely.
So there's no security of tenure, there's no consistency, go ahead, yeah.
No, I just wanted to also add that the Guwahati High Court has ruled that it will keep a close eye on the appointments and extensions of Foreigners Tribunal members. But what we argue in the report is that there seems to be no evidence to suggest that High Court is playing that role to, in a way, moderate these appointments. So neither is there legislation, and even if the Guwahati High Court may have said it, there seems to be nothing available in public record to suggest that there's meaningful oversight over these processes, and these continue to be a completely political process.
Right. And since these tribunals are not part of the ordinary hierarchy of courts, they don't get training at the judicial academies, they don't otherwise have all of the other protections that judicial officers have from any kind of external pressures. So even though they are deciding something so critical, they have, in that sense, none of the trappings of an ordinary court.
Absolutely. And I think that has to be repeated. These entities have no independence, no guaranteed competence, no meaningful oversight in legislation or institutional structure. And they might be deciding one of the most important constitutional values we have, which is whether a person is an Indian citizen or not. And the consequence of that is not only loss of citizenship, denationalization, and potentially statelessness, but also tremendous human harm.
So one thing that the report does that I think is very illuminating is sort of walking you through the tribunal process. So like we just discussed, a person gets a notice overnight. The notice has no reasons, makes no reference to any grounds of suspicion against you. You just have to show up to the tribunal on a particular day with that notice in your hand. And then what does the tribunal do thereafter? Can you kind of give us some examples of how the tribunal is deciding this question of citizenship for people who come and are forced to now justify that they are Indian citizens despite being born in India and being born to Indian parents living in India?
What we have tried to do in the report is to go stage by stage in these foreigners tribunals in order to really understand what they do based on our case studies. Because as would not be surprising, it is quite difficult to access the everyday reality of the foreigners tribunals because these are not transparent bodies. It's very difficult to access them. And in fact, there have been many stories in which the foreigners tribunal member has asked non-lawyers or non-litigants to basically leave the room. So that also raises serious concerns. I think one way to understand the challenge, and I would believe the crisis of justice in these bodies, is how burden of proof really operates here. So as I said, Section 9 of the Foreigners Act places the burden of proof on the persons defending their citizenship. But it is also known, and in fact, the Guwahati High Court has ruled that the onus can continue to shift. And that makes a lot of sense, that even when a burden would be on the defendant, the state must also provide evidence and prove its evidence, not only by providing inquiry reports, but also to argue why it believes that the evidence presented by the other side is not up to the mark. But what is going on in the foreigners' tribunals is that this whole idea of shifting onus and the burden, while continue to remain on the defendant, has been completely frustrated through different mechanisms. So one mechanism which I already mentioned is that the foreigners' tribunal members do not demand that the state provide initial reasons, grounds, materials, and inquiries. The other way in which this happens is that the foreigners' tribunals do have the power to issue summons like civil courts, but the foreigners' tribunals systematically refuse to do so. And what they say is that the defendants must not only prove their case, but they must also get corroboration, often in the form of officials, to come to the foreigners' tribunal in support of the documents that these people are presenting. Now, one can only imagine what an ordinary litigant in these processes would not be able to do. There are cases in which the foreigners' tribunal has said that the defendant must get the electoral officer or must get a police officer to come and support their claims. So there's a systematic refusal of issuing summons. The state lawyer, the government pleader, is as a rule absent from these proceedings. Now, another major issue here is that the foreigners' tribunals do not demand the presence of government pleaders. In fact, as a rule, we found through our case studies that the government pleaders are never there. And what that basically means is that all the practical burden of getting evidence, of getting corroboration, and also proving the case falls on the litigant. And often the foreigners' tribunal member himself becomes the cross-questioner in these cases. So the overall environment in these contexts is not very amenable to fair trial, in other words. And even the way these foreigners' tribunals are appreciating evidence is of great concern. And this is documented quite widely now. So for instance, these foreigners' tribunal members don't read evidence together. They often dismiss documentary evidence based on minor changes. A very common example, which often affects women the most, is if there are minor changes in names after marriage, or if a woman becomes a widow and her name gets changed to Beva or widow on the electoral rolls, then the foreigners' tribunal members would say this is not the same person. Or if a person goes for pilgrimage and he adds the name Haji before his name, then again these names are rejected. Minor discrepancies or minor inconsistencies, for instance, adding titles like Sheikh, for instance, in an electoral roll, becomes a basis for these foreigners' tribunals to reject documentary evidence.
It's important to remember that these individuals don't control what's actually recorded in electoral rolls, especially in earlier rounds of enumeration that occurred decades ago. And one thing that your report points out too is this is not a situation where people don't produce documents before the tribunal. They in fact bring a phenomenal amount of documentation tracing back to the 1950s, but the manner in which these documents are treated and the ways in which they are rejected, that results in them losing their case and a declaration being made by the tribunal that you haven't discharged your burden, even though it's supposed to be a burden on preponderance of probabilities. The standards applied are certainly beyond reasonable doubt, and it becomes almost impossible to win a case. I'm reminded of one of the cases that I argued in the Guwahati High Court, where we were trying to persuade the Honorable High Court that oral evidence is a very important source of evidence in these cases, despite the existence of documentation. Since you have to prove your citizenship under the 6A standard in Assam, you have to trace your presence in the state prior to 25th March 1971. So for those who are born after that date, they have to show that their parents were ordinarily resident in the state prior to that date and they were registered as voters. Now people bring the electoral rolls with their parents' names, but the tribunal and then the Honorable High Court disbelieves that they are in fact the children of those people who they say are their parents. And the real parent is brought to the tribunal as a witness, examined, cross-examined, but their testimony is completely ignored, not even considered as a valid source of evidence. Even though Section 50 of the Indian Evidence Act says that particularly for proving relationships between individuals, oral evidence is an important source of evidence. So we try to point out to the Honorable High Court that for women especially who are not given the privilege of completing schooling, they don't have any matriculation certificates, they were not enrolled as voters prior to their marriage. You have to remember that the age of voting was 21 before it was reduced to 18. So they were married much before they became eligible to vote. And then they moved into their matrimonial home. So they don't have any documents that show who their parents are. There are no birth certificates in the 1950s, 60s and 70s. So it becomes, even though they have documents to show the existence of their parents, where they really struggle is documentary proof that they are in fact biologically related to a person who is present in the tribunal and saying, I am the mother of this person, I gave birth to this person.
Yeah. As in another case, and that's spot on, another set of cases that really reveal even the gendered character of this is the whole debate around Gambura certificates. And I think that's also quite important. So most women, because of precisely the reasons that Rupali mentioned, are often able to only get documents like Gambura certificates, which are these certificates issued by the elder in the village. And there has been a long debate even in the NRC whether these certificates should be accepted or not. And ultimately, Supreme Court said that they should be accepted. But the fate of these certificates in the foreigners' tribunals is quite shocking. So one example which comes to mind is the case of Hazara Khatun, where she presented all kinds of evidence, electoral rolls were there, ID cards were there. And one of the evidence she presented was the Gambura certificate. And in fact, the Gambura himself came to the tribunal to corroborate the certificate. And his testimony was rejected because he did not remember the names of all the siblings of Hazara Khatun. He did not remember when Hazara Khatun's father, which year he came to the village, even though he did say that he knew the father, he knew the family for 15 years. And this is really serious because these kind of documents often are the only ones that many people, especially women, are able to rely upon. And then they are rejected and viewed upon from this deep sense of suspicion rather than from a sense of fair play.
Another reason the Gambura certificates are rejected is the fact that they have the state emblem on them, which is bizarre to me because the Gambura is a civil post under the revenue authorities. There's a constitution bench decision of the Supreme Court saying they are a civil post. And despite this, the tribunals have said that they are not authorized to use the state emblem and hence their certificate has no value and their evidence in court has no value. This is an issue that is now being litigated before the Honorable Supreme Court. But this, takes me to the question of if there are these very palpable, very overt, patent problems with the ways in which the tribunals are deciding cases, what has the role of the High Court been in correcting these errors? Now, you've already pointed out that there isn't a full appeal against the orders of these tribunals, which again is a huge anomaly. The CPC and the CRPC give you at least one full appeal. It's been held to be a part of fair trial, but here there is no full appeal. So, though you are approaching the High Court under certiorari in a writ petition, you can still raise jurisdictional errors, you can raise errors apparent, and many of these are certainly errors apparent. But you have analyzed 1,193 judgments of the Honorable High Court across a 10-year period, 2009 to 2019. And it doesn't seem to be, from the conclusion that you have made in the report, that there has been any meaningful clarification of this law or correction of these sort of very serious errors. So could you tell us a little bit about that?
Absolutely. No, you're absolutely spot on. We were quite shocked when we started analyzing these orders from 2009 to 19, which are 1193 orders. We also studied selected orders after this period, but over the period of 2009 to 19, we tried to get all the orders we could. So we can safely say that they are representative of what was going on in the court in that period. And our subsequent studies also suggest that fundamentally things haven't changed, particularly over the last 2 to 3 years. And there are several problems. And I think one problem is a lot of inconsistency. And overall, what is happening at the High Court level is that there is a dedicated bench that deals with foreigners' tribunals, but the High Court has not consistently created a systematic jurisprudence about how the foreigners' tribunals should deal with these matters. So I can start with the question of certiorari. As Rupali said, that the High Court actually has held that it is not going to hear appeals from foreigners' tribunals, which from a legal standpoint is not an objectionable position, of course. And what the court has said is that certiorari is a limited power of issuing writs, and they are not going to look at facts. But jurisdictional errors will still or should still be considered by the court. And as I mentioned, when there are cases in which when people have challenged non-issuance of inquiry reports or not providing grounds, then the High Court, rather than considering this as a fundamental jurisdictional error and quashing proceedings, has actually sent it back to the Foreigners Tribunal. There's another case which we document in which the police and the inquiry report itself said that the person was actually an Indian citizen. Despite that, the police referred the case to the Foreigners Tribunal. On that basis, the petitioner went to the High Court and said that not only are the grounds material not provided to me, but in fact, what I've come to know is that the inquiry report actually and the investigation actually found that I am an Indian citizen. And despite that, the SP police had referred the case to the Foreigners Tribunal. This appears to be a fundamental jurisdictional error. The High Court did not quash the proceedings. The High Court said that this case must continue to be heard and evidence must be provided. So rather than taking the question of initial preliminary objections seriously, the High Court has not done that. But there are other problems also with how certiorari is being decided. Because had it been the case that the High Court had been rather consistent with its limited intervention in these cases, because it involved a writ of certiorari, then perhaps one could understand. But what we found is a pattern in which the Honorable High Court has actually, after saying it's a limited intervention in certiorari, gone into facts. So we have cases after cases in which the High Court has actually appreciated facts, often repeated facts and agreed with the Foreigners Tribunal. And there are some cases in which it has said that the Foreigners Tribunal may have been wrong in its appreciation of facts, but then supplemented the case and found other facts based on the record and then held the person to be a foreigner. The other major problem is we found a pattern in which, despite saying that the High Court did not want to intervene because of limited scope of certiorari, in fact looked at facts, appreciated facts, often supplemented findings by the Foreigners Tribunal. One example which we have reproduced in great detail is on page 78 of the report, which deals with Hasina Begum's case in 2016, where she had filed the case against the Foreigners Tribunal, arguing that the Foreigner Tribunal had not appreciated the factual arguments she had made in the tribunal. And what the Honorable High Court held was, and proceeded to do, was rather than saying that it did not want to appreciate fresh evidence, went into appreciating fresh evidence and actually supplemented the reasons of the Foreigners Tribunal to ultimately agree with its final finding. There are other concerns as well. I think one important area which has been of great concern involves res judicata. And in fact, res judicata applies to the Foreigners Tribunal cases, because in the Abdul Quddus case, Honorable Supreme Court held that the principle applies to Foreigners Tribunals and the same case cannot be proceeded against the defendant again and again. But despite the Supreme Court's ruling in several cases, including in 2023, there is Rafiqul Islam case and Amir Ali case, where the High Court doesn't seem to have applied this particular ruling of the Supreme Court. So we do see these several inconsistencies. Another example which I may give, which also worries us a lot, is that the High Court seems to have decided many of these cases on a case-to-case basis, and there's a pattern of contradictory decision-making. So in some cases, for instance, dealing with ex parte cases, and 40% of the declarations of foreigners in foreigners tribunals are ex parte, and a sizable number of writ petitions against FT decisions are also challenging these ex parte decisions. And many of these cases involve the interpretation of the doctrine of sufficient cause. And what we found in the report was that the Honorable Court was often not defining the requirements of sufficient cause, or in cases, for instance, involving legal representation, sometimes dismissing the case without telling us exactly why, or in some cases actually accepting the argument in quote-unquote in the interests of justice without telling us exactly why the case should have succeeded in the court. So there are these several inconsistencies and contradictions that unfortunately emerge from the record of the Honorable High Court. And a major reason that might be happening is because these cases are being decided on a case-to-case basis, rather at the level of providing wider jurisprudence and guidance to how the FTs, the police, or even the defendants should go about fighting their case.
So there are two important issues you flagged. One is the absence of uniformity and the absence of clear standards. We've already discussed that there is no statutory regime, so there are no standards that come from statute. And it has been held by the Honorable High Court that neither does the CPC apply, nor does the CRPC apply, nor does the Evidence Act apply, so it's entirely ad hoc. And the Foreigners Tribunal order says that each tribunal will evolve its own procedure. And there are 100 different tribunals across the state. So each tribunal means 100 different tribunals are evolving its own procedure. So there is this vacuum that existed already, which gave rise to this immense set of variation in outcomes, in standards, but the uniformity that we would hope that a constitutional court would bring into the system hasn't emerged. So you know, in your conclusion, you say that individuals facing proceedings of the gravest kind, potential loss of citizenship, are too often left without clear guidance as to what is required to establish their claims. So it's a constantly moving target, and that makes it very difficult for lawyers as well, in the cases where there are lawyers, to successfully know how to litigate these cases. So maybe can you tell us a bit about what the lawyers you spoke to said about the experience of appearing in the tribunals and doing this work in Assam?
It was amazing to talk to many of these lawyers, because the conditions in the foreigners tribunals are not amenable to good practice. Because many of these lawyers we spoke with were experienced lawyers who had also practiced in the High Court. And what they told us was the environment in these tribunals are extremely oppressive. Because there's no process which is followed, which is legally legible, they often were quite taken aback by the idiosyncratic behavior of the foreign tribunal members. Sometimes they said that when they demanded that certain documents be presented, including important evidentiary documents like inquiry reports, then the foreigners tribunal members would just refuse. There's also a climate of intimidation where ordinary litigants find it very difficult to participate in a meaningful way. And often, and I think that's one of the most worrying things we found in these case studies, is that whenever an argument is made, it's quite difficult to even put that on record so that a meaningful writ petition is filed. So for instance, if a lawyer told us that when he asked the foreigners tribunal member to issue summons, the summons were not issued. And when he said, can you put that in writing, that also did not happen. So there is this insidious way in which many of these things are kept off the record, and that unfortunately is what the institutional culture in these places is emerging to be.
So Mohsin, with this kind of, like you said, idiosyncratic system, we face a very serious question of whether there is an Article 14, 19 and 21 violation. The Constitution requires fair trial, it requires natural justice, it requires substantive due process. So in your scholarly assessment, based on this very in-depth analysis, do you think the foreigners' tribunals meet this constitutional standard?
Foreigners' tribunal system absolutely violates every element of our constitutional jurisprudence. We have divided our report according to those precise constitutional values, which are informed by international human rights law, starting with the rule of law. Bodies that are deciding our fundamental rights cannot be based on a system in which there's no independence and there is no competence. These foreigners' tribunal members are not constituted by legislation, and at least in the report we have made a strong argument that they exist without legal authority as required both under domestic law and international law. We believe that these foreigners' tribunals violate effective remedy, which is a right of fair trial under international law, which we believe is guaranteed under Article 21, because a fundamental question of citizenship is being decided without an opportunity to review it in a meaningful way or appeal against it. And because these foreigners' tribunals are kept outside the court system and are not then supplemented by any meaningful judicious process, fair trial rights are violated. We have also argued by looking at the steps taken by these foreigners' tribunals in the procedure that due process and natural justice is violated. There is no equality of arms, as international human rights law calls it, because the way burden of proof is operationalized in these bodies places a completely unfair burden on the litigant, on the defendant, and places absolutely no burden whatsoever on the state. And in that context, there is complete inequality of arms and violation of natural justice. And overall, there is no meaningful supervision, either under legislation or under writ jurisdiction of the higher courts, to make this process in any manner feasible in a constitutional democracy like ours.
Thank you, Mohsin. So hopefully this report will help those who are outside this experience to understand the legal issues and also understand the ground realities and how both of those things come together in the foreigners' tribunals. I want to congratulate the authors of the report, you and your colleagues Arushi Gupta and Shardul Gopuchkar, for your excellent work. And I would urge all the viewers to also take a look at the report, go through it, see the human stories in the report, and also the meticulous legal analysis, and then make your own conclusions on the legality and the constitutionality of this system and what we need to do next to reinstate rule of law when it comes to citizenship determination in Assam. Thank you so much.
Thank you, Rupali.